ಮೊಬೈಲ್
ಇಟ್ಟು ತುಳಿತವನೆ.
Avyasha, please turn on your microphone. Shall we start now? Sukrita ma'am.
Yes, Shafia, you can start.
Yeah, I hope I'm audible.
Yeah, you are audible.
Okay, ma'am. Thank you. Yeah, so hello everyone. I Atya Samin, Assistant Professor and Head Department of Microbiology. It's my pleasure to welcome you all for the 5 days FDP on IPR organized by IQAC of our college MMK and SDM Mahila Mahavidyalaya. I welcome our enthusiastic principal, Professor Bharati N. A warm welcome to our speaker, Mr. Irfanullah Sharif, Chief Scientific Officer, Prozai Healthcare, Mysuru. Welcome you, sir. I also welcome our IKC coordinator, Srimati K.S. Sukruta, HOD of Computer Science. I welcome you, ma'am. I would like to welcome our organizing committee members, and once again, I welcome all the participants for the FDP program that is on IPR. So let me introduce our speaker. I'm delighted to introduce our speaker, that is Mr. Irfanullah Sharif, who will be sharing his insight on trademark and trade secrets, copyright protection and infringement. So Irfanullah Sharif is a chief scientific officer. He has 24 years of experience in industries like Sami Sabensa Corporation, Biocon, Triphase Pharmaceuticals Private Limited, established probiotic company from research activities to product commercialization, certified corporate director, masterclass for directors from Institute of Directors, certified internal auditor for ISO N001-2015 from TUV Nord. Mr. Irfan has developed technological transfer methods that is in Japan, that is Taiyo Kagako Limited, and also probiotic bread development, American Institute of Baking, that is in USA. And sir also holds 4 patents: US patent, European patent, Canadian patent, and Indian patent. Sir has good number of publications in a reputed national and international journals. Sir has also attended several conferences, including among which 10 international conferences Sir has attended in USA. Sir has also successfully cleared national international audits of various regulatory requirements. So, sir, your expertise is greatly valued and we appreciate you sharing your insights here. So, we are truly honored to have you with us. So, it's over to you, sir.
Thank you, ma'am. Thank you for the quote to this one. And I believe we have been having a lot of this ones from past 4 days on IP. So I myself have a couple of patents and handle local Indian and international PCTs also, office actions and what is the mode. I think our previous speakers have already given you an output and overview of all these things, what has happened. And I believe, most of them who are today here of faculties and teachers who are working in various institutes and organizations. Am I right, ma'am?
Yes, sir.
Okay. So basically, today
Your
we'll
screen
be
has become multiple, sir. Can you please?
yeah, yeah. Just is my
Yeah,
screen okay now? I'll
yeah,
show you
yeah.
the PPT. Yeah.
Yes, yes.
So basically, we have been talking on a lot of IP. Uh, in IP, there are a lot of concepts actually, and our previous speakers have already spoken a lot on all these things and how to do IP, how to file, or different types and other things. So I'll be trying to concentrate on understanding the trademark, trade secrets, and copyrights. And I think this is a very simple concept, and most of them also have a knowledge about it. But when it comes to really doing it, it is a little bit different scenario, keeping in mind the laws of the country where you're filing it and other things. So, in my PPT, I'll be slowly going through a lot of simple concepts, I think, which will make you people understand better. Because I saw that one couple of days, the number of people asking questions are low, and couple of times I also ask questions because I'm aware of it. And as faculty members and other things, people have not gone into these kind of IP concepts. Keeping that in the mind, I've made it very simpler for the PPT to understand everybody and have any doubts we can go ahead and ask with other things. So with this, I'll start my presentation on understanding trademarks and what are trade secrets and copyrights. So basically, we all know about IP by this time, a little bit at least. So IP is nothing but it is an intellectual property. It talks about legal rights of protection of certain kind of inventions. It may be your names, your symbols, designs, artistic works, and a lot of things which people have gone ahead and created so that nobody else can go back and rework it and redo it. And we all know that in Asian countries like Chinese and and we also in India, we are good in doing back reverse engineering, and a lot of them depending on their kind of departments or works or segments, people try to copy a lot of things because of which the real inventors who have spent a lot of time and energy on that at the end, if they don't take care of those IP rights, they end up in losing a lot of things. So in my presentations, I'll show you a couple of cases also, which will make you very clear and understanding and how this IP on trademark copyrights and trade secret works. So there are different types of IPs. One are patents, which you've already gone through. The other includes copyrights, trademarks, and trade secrets. Now, what are all the purpose of IP is to encourage innovation and protect the creators rights actually. See, a lot of companies who invest in people and manpower with keeping in a lot of infrastructure and things, because I come from the industry, I do have a lot of industrial experience, work with a lot of MNCs. So when we hire people for our work, what we do is we try to sign a confidentiality agreement. So any IP created should not be taken away. And we all know a lot of them who work in companies and all, once they move out, they try to take a lot of confidential information. So keeping that in mind, companies like Sammy Sabinsa, it's an MNC back on, and my previous company where I work, we also has to have contracts. Even I, as an inventor, had to have a contract with them that I should not reproduce it somewhere else because it is somebody's money gone in. Maybe my idea or my brain has gone in, but we try to keep that confidential. So it is a very important step in protecting the creators' rights actually. So going directly, the picture shows that a lot of brands. We go to we also purchase a lot of brands at home. It may be a food or a clothing or a shoe or a jewelry. We all know a lot of brands are there. Now, why brands are there? To recognize that there is a product coming from some company. So my slide typically talks about a lot of information it gives you. So basically, what is a trademark? So the simple definition of a trademark, it may be a symbol, it may be a word or other indicators used to distinguish goods, services of somebody's business. So it may be business. Basically, it will be relevant to business only. As you see, there are a lot of examples on trademarks I've already given, which you all are aware. It may be a Tata, Mahindra, Taco Bells, or Bata, your Bisleri Water, Hamdard, or automobiles like cars or IT industry like Yahoo. There are a lot of them actually. And what are these trademarks? What are trademarks are nothing but it may be a brand, logos, it may be a design and slogans. Now, what is the purpose of the trademark? Trademark is to protect the brands and prevent consumers confusion. I've given you an example here in the right side. If you see, everybody knows about Starbucks, right? So the Starbucks, what one person did in India, he created similar one known as Sardar Bucks Coffee and Co. So this is a infringement actually. We cannot, just because it is an American brand of Starbucks, you cannot just copy it and do all this reverse work, which will create confusions. And the Starbucks India and the US had to put a case on this company on Sardar Bucks Coffee, who copied a lot of stuff from there. So this is one infringement which they did, and people will not know what is a brand. So that's why you see, to protect the brands and prevent consumer confusion, these kind of brands, it may be in the form of a logo or a symbol or any other thing which they have created, which will help us understand whose trademark it is and whom does it belong. So followed by that, we all know that we have trademarks. If somebody wants to really do a trademark, it may be depending on the kind of business they are running, or depending on the segments they work. It may be a biotech, or it may be a pharma, automobile, IT, a lot of industries. It may be an institute who wants to create some names or slogans below their institute names. So since you all are coming from institute, each institute has a punchline below that. So if it is, that can be also trademark depending on the availability and others. So here, simple steps. How do you register a trademark? It is very simple. I have given two website links on the ipindiagovernment.com, that fees. It talks about the fees and other things. And in that subsection, you can go to trademark research, because the ipindia.gov.in shows a lot of things. It may be filing patents and other work which they do. So specifically, if you go there and go to subdivisions, depending on whether you want to do a trademark or a IP, so those are the links which are available there, which you can go and click, and it will lead to a different five-step process, which includes search the existing trademark to ensure originality. Because when you put something which you want to put, immediately in the search, it will show that here it already exists or it not. So based on it, you can decide whether to further proceed to the next step, which may be filing. So initially, the first step involves your punchlines or taglines or logos or designs which you want to do, which can be searched on the website. If similar ones are there, it may try to say that it's an already existing one, which again you can go back and rework and tweak it. Then if it is accepted, you can move to the next step, where we prepare the applications, write the descriptions, samples of mark. Like it may be, it will take you to different segments of the trademark. In the trademark, there are different segments. If it's a biotech, there is a segment. There is automobile, different segment. So depending on which kind of segment you're working, it leads to that kind of preparation of the application and filing. So finally, when you do the step two and submit all the necessary details which were required, which are shown on the website details, when you submit the details, that submit to the trademark office. So it goes to the trademark office, where it will be allotted to a concerned person of a concerned department. Like I come from a lot of biotech and science and pharma background. So if I'm working for organization from government through this, so it will come to me if it is a relevant to my subject. Or if somebody is in automobile or IT industry, they push it to somebody who's an expert to review the submission in the office, where they examine it, whether there is something already existing like this, or you are working closely with similar already existing one, where somebody should not come and put an infringement on you. So they try to review all the examination and other things. Then after everything is cleared, you they give you a approval, and if there are some changes which has to be mentioned, they suggest you those changes also. Once everything is done, the step four involves for a possible opposition. If some opposition is raised by somebody, so they will tell you that also, boss, you can't do this because there is opposition which may be raised. So you need to wait for the approval, because we all know that I have put a small tag in the duration. So every trademark has a typically lasts for 10 years, and it can be renewed. If somebody has not renewed it because of some financial issues or company closing down, or they're not continuing with the trademark, so that day what they do is they try to raise an opposition and try to ask the concerned person if this can be given off to somebody. So that provision also is there. So these are all work done by those expert people who are into this domain. So we will not have access to those kind of this one. So there are a lot of institutes or government bodies which do all this search. So once all this are cleared, they give you an approval that here you can go and do a trademark this one. So initially they do a TM they do. So after some years in duration, if you want to further go and register it, you can register it also. So this slide talks about 5 simple steps of how you can do the trademark register and what are the steps to be done, what kind of hiccups may come if there is a possible opposition or waiting period done. All this will be given in this. And as again, I'm telling you, it takes typically lasts 10 years and the trademark can be renewed once you complete 10 years by paying a small nominal fees what the government body has decided. So moving on to the next slide. So this one, what I talked to you about is the Indian steps. So some people who are willing to do global trademark, it's a different procedure. So again, in our previous speakers talk about WIPO and other bodies who are the World Intellectual Property Organization who support patents and other things. So along with the patents, the WIPO also helps you do an international trademark registration. So they're all again different steps of them depending on the application. Like stage one talks about basic application, registration of basic marks, what and all you want to do. Then further it goes to the office of the origin where somebody international application is forwarded to the WIPO. Somebody will analyze it in the WIPO. The second step involves what and all you have submitted. A similar example, but they do it in a different way there. They do a formal examination with this. They'll see the because it is your global where you're applying. And one more thing, what we do as industries, like yesterday, we have been listening to a lot of our previous speakers talking about filing patents in India and outside country. Outside country involves a lot of different kind of scope work from even English. If you write in Indian English, those claims cannot be confirmed. So they suggest you that it has to be done. And how they register, how do you think we should register internationally, where should I go? So if I am a company owner, if my business is in certain countries, so we should select only those countries where you are planning to do the business. We should not go and select all over because it comes at a cost. International trademark and IPs comes at a very huge cost because of the amount of our currency values. So international trademark registration, they have a process where they take the formal examination. They check the country where you are interested in registering it or trademarking it, whether something exists in the similar one. Similar examination, they also do. Once they do all this checking and this one, they register the notifications and other things. They write you emails and communicate that, these trademarks, what and all you are applying in the form of symbols or slogans are already existing. You need to change or something. If it is available, they'll quickly move to the third stage, where the third stage, there'll be office, it will be designated to a contract party from the WIPO who are WIPO bodies only. So they work for them. They'll uh, send it off to them. And depending on the country, they and their domestic law and labeling requirements, slogan requirements, size, shape, and other things, they take their time. So here within 12 to 18 months, you can have the this one also. Followed by that, they try to push it to the different designated contract parties or the contracting parties. So we all know, we do sublease to somebody else. That fellow will sublease to somebody else. So they are global also people depending on their expertise. They would have opened some service industries where they would have taken these um, uh, kind of processes, which they are also sublease to somebody else depending on the country where you're doing. So this is for the international trademark registration process, which is a kind of a different flow and comes at a different card compared to India. Followed by that, we all know, I've given simple examples so it be easily identified. So brand identity is one of the importance of trademarks. It is very important because we all wear a lot of clothes. It may be a lot of clothing brands which comes in. There are a lot of them in the market now. So trademarks helps you creating a unique identity for a company. It's like as soon as we know Starbucks, we all know, yeah, it is coffee. As soon as you say Tata, we all know they are in different divisions, but everybody says about cars and automobiles and all this. So without even knowing here who is the owner, we know that there is a brand created and people already know about it. So that is where a lot of people pump in a lot of money in marketing and branding As a scientist, I have developed a lot of products and I do have patents. But when it comes to branding a product and pushing it, I may not be good. So we need to take some expert um, who are good at these creating creativity things or who are designers to show. So, I've given an example on the right side, importance of trademark. You see the cup of coffee and the other side, which is unknown. People hesitate to take. We don't know what it is there in that and what kind of drink it is. So by branding it and seeing all this publicly known other things, so that gives you a quick response here. It is something valuable and so it is coming from a branded company, and that also helps customers protection. So helps consumers, know that you're purchasing is good. You're doing a right purchase, like because it is not unbranded, it is not something. It's a brand, and it comes at a premium price. We all know that. So that gives you a recognizable trademark to your brand, whichever you do. So again, along with all this consumer protection and brand identity, it is very important to register it to all this because it gives you a legal protection. Tomorrow, somebody should not copy. In my previous slide, I showed you Starbucks. Somebody has copied. Sardar Bucks has copied it. So he was sued for copying all this, and by all this, he had to end up into a legal case, paying hefty amount. So there are a lot of cases which I'll show you in my couple of slides. So that all trademarks important gives you a exclusive right to protect your trademark and prevent others from using it without your permission. That's very important. Like we all know, nobody can click a photo of us without asking us. So if there is a importance for us to, and we have a freedom for that, and obviously, if somebody has created a brand, it is very important for others to not to misuse it without anybody's permission. So that is what this trademark is, and which is very important when it comes to legal protection. Then I'll show you a small case study on trademarks. So we all know about Nandini milk. I mean, most of them consume milk. So, apart from that, there is a Nandini restaurant also. We all know. So what they do is, so the Nandini Deluxe and the Karnataka Cooperative Milk Product, they put up a case telling that it is my brand name. You cannot use it. So I have given a small hint on the literature on this level. The Nandini Cooperative had been using this milk and related products registered under Class 29 since 1985. The appellant Nandini, that is just a difference of H in their both the brand names. They are a chain of restaurants in Karnataka which used the trademark name from 1989. Then they started both the appellant, who is the Nandini Deluxe Hotels, they applied for the registration of trademark under Class 29. The Class 29 of the Registration Act talks about of the products like meat, fish, poultry, preserved, dried, cooked, jellies, jams, eggs, and milk and milk products, edible. So that class controls all the food products and so on. So they went ahead and registered it by the Mark Nandini as a distinct exception. Then they started arguing, and Karnataka Milk Federation, they also argued with in the High Court. Then and they found out only there is a difference in these two brands, only trademarks Nandini, which is deeply similar, except without being a difference of H between the two marks. So finally, the court did the thorough investigation, and by taking out all the proofs and understanding the laws, clauses, and different sections of food and other things, then the Supreme Court finally concluded that no one can claim exclusive right on monopoly or entire class of goods because the Nandini Deluxe, they had written all the class of goods. So they told that, boss, you cannot claim all the class of goods. And Nandini Deluxe restaurant doesn't sell milk and milk products. So why did you, if you're not selling those products, you don't have the right also to hold that Nandini, your Karnataka Milk Federation should not to do it. So then finally, the appellant Nandini Deluxe was, because of lot of data and other things, Nandini Deluxe was granted permission to use this mark after removing the milk and milk product category because they don't deal with it. So this was one infringement case which both of them fought and they did on the trademark. So which finally the Nandini Deluxe had to remove their milk and milk product class from their category, and that went on because they're not selling anything with milk and milk products. So this is one case which was an infringement case study on trademarks in our Karnataka itself. And similarly, I'll show you one more case. We all know about Amazon. Amazon has been there in India for quite some time, and There was one company known as Happy Belly Bakes. So this Happy Belly Bakes was a company which was founded in 2008. It's a woman-owned business. Used to sell baked items, like cakes or cookies or something. So it used to own the trademark of this name Happy Belly since 2016, and the this trademark was used in inception in 2008. So it went and saw after some days that Amazon was using their bakery kind of stuff available, and they were selling without their permission. So the Happy Belly company sued Amazon for selling bakery items, snacks, and dairy under their same brand name, and they had to put a case and went to the infringement court. The court held Amazon infringed the trademark, and with the kind of sale they do, everybody has a fine to pay, and they end up in paying fines to Happy Belly Bakes depending on the kind of sales they did. So the court gave verdict in favor of Happy Belly against Amazon. Now imagine people in India who don't want to spend money. It may be a small money that time when they are registered. And companies like big companies like Amazon who came outside the this one in India and started their chain and they are multi-crore business. If they would have not trademarked Happy Belly Bakes, they would have not got anything. They would have not got anything. Maybe they would have ended up losing that trademark also. Luckily, people who are doing business, they trademark it. So that's how it protected the consumer, their brand, and the legal this one also. So Amazon had to pay a hefty fine for depending on the sales. So the verdict went to Belly Bakes, Indian-based company, woman-owned business. So Amazon, such a big company, had to give up because he misused their and infringed their trade. Similarly, we all know a lot of undergarment brands like VIP. So VIP came up with one. This one known as Benz for the undergarments. And we all know that, Mercedes-Benz is a very world-class company and it's a global presence and, they are there since so many years. So this was also one small case which I wanted to tell you, so it was diluting their brand. And, the kind of logo you see somebody with a Benz logo and a triangle shape, they did started and selling these undergarments. And the Benz company had to, Haibo Hindustan was the company name who was selling this brand. They had to infringed them and made a case on them, and they removed it. Now after that, that brand was wiped off from the market. It was not available for some time, and they went up and sent to some other branding of it. And the Benz, Mercedes Benz, had a case on them and sued them that you're misleading and you're diluting our well-known trademark brand with some other than. So this is also one international infringement case of this one I showed you one Indian local. There are a lot of like this small cases, and these are all well-known brand. We all know all these brands, so that's why I thought I'll share you on how infringement takes place and how people try to infringe if you don't have a trademark registered. It may be legally or financially. Followed by that, I will now you have a better picture on what trademarks are and how to file, and if you don't file, how somebody will copy it. If they copy, who will um, the how the infringement can go legally, and we can catch hold of these people who are doing this kind of infringement. Followed by that, I'll come to trade secrets. So we were talking about for some time it was trademarks. Now I'll be talking about trade secrets. We all know that trade secrets. Trade secret is nothing but whatever you try to trade. There are a lot of brain behind gone, lot of invention, lot of things. So when somebody starts selling those kind of products in the market, and as makers in the company who employ people to work for them and start manufacturing, they end up in copying a lot of things and going and trying to reproduce and making a money out of it. So here I will be talking about this trade secret. So I've given them three very good examples, which we all know in our daily life. You pass anywhere, you get a lot of ads on the TV or on the malls and other things. You see big ads because they're all very big brands. So a simple definition on a trademark trade secret is just a business information, or it may be a process, or it may be a recipe, it may be some formulation which is like WD-40. WD-40 goes and removes a lot of things which cannot be removed. I mean, it is a de-stainer, a lot of multiple application, and nobody knows the formulation. So you have to keep it confidential to maintain that competitive edge. I come from a pharma industry. I've been working with a lot of MNCs. When we used to develop a lot of fermentation formulas, like what the bacteria has to eat, what kind of sugar, carbon, nitrogen, what process. When we used to do that, what I used to do is to my subordinates as a director for research in my previous company, we used to give code numbers for if it is a sugar, no, we used to give an internal code by giving some numbering. So like that, we used to mention codes on the raw materials which are used for fermentation. And we should tell in right in the BMR. So BMR is a batch manufacturing record where you have to do a documentation of what you're adding for a particular product. So we used to give codings so that the people or the end users, even from the stores, the store person is responsible for purchasing a lot. He'll be aware of the usage, but he'll not be aware what is what. Once he knows that it is dextrose or some nitrogen or yeast extract, we don't give out details. His work is to just see that that metal has come. So when it comes to coding, we as directors, we used to allot certain code numbers to all these raw materials before it getting dispensed for the manufacturing. So we used to sign a lot of documentation from all the employees, so that there'll be no secret going out of certain things which people have spent a lot of money, a lot of brain has gone, a lot of money has gone to develop these things so that tomorrow in simple way, ready-made, somebody cannot copy it and move away. So trade secrets are very important for business information. It may be any kind of business. We all know that Coca-Cola is something a lot of people are trying to reproduce. We're not able to reproduce because it's a trade secret. That's how they are able to make that much kind of sales here. So one example, very good example, is the Coca-Cola recipe, or it may be your KFC's manufacturing process with respect to the food what they supply, or it may be a business strategy, it may be a customers list, it may be a software algorithm. So there are trade secret. Customers list plays a very important. In India, what nowadays people are doing is, if a lot of companies export to the country to different countries, they pay around 10, 15,000. These people who are traders, they go and pay money to some traders, especially the shipping and logistic industry, because shipping and logistics industry, they have all this data because they know from where the material is coming and to which country, to whom it is going, because they are the one who are shipping it from the destination, from the initial manufacturing to the client. So these companies, what it is, employees who work there, they try to steal a lot of data from different countries depending on the product category which is getting exported from our country to different countries, are getting imported from import from other countries to India. So they steal all this client data, and they are a lot of organizations. When you try to search in Google, no, that list of companies I am looking, immediately there are a lot of people who show up, and immediately you select something, they'll call you also, boss, you pay me. They'll show you the outline that this is the information I'm gonna give you, and if you pay them 15,000 to 20,000 or 30,000, depending on the kind of data, they give you all the data. So these are the companies who try to uh, do all this. Now, we all know software has been implemented for controlling all this. That's when the software algorithms or softwares or securities are built up in the system so that nobody can transfer data. There is something we all know about SAP, and I used to, before SAP, we had a IMIS system. Like if I'm entering some data of the company, it will be there in the company only. Nobody could take out the data out of the company and go. And that's how the trade secret works. It may be your software which somebody is trying to steal, or codings, or business, or manufacturing of food, or beverages. It is a secret, so that employees working for me should not copy. My current employee, where I have my employees, I don't give them more information on all this what we're doing. So we give them their JDs. JDs are job description. This is what you need to do, and this is what you have to follow the SOP and get it done. So you don't have to know what is the ingredient going in, who is doing it. So it's kept as a top secret. So when we sign an employee agreements, especially with MNCs where I have worked, we used to sign all this one. So once you come out of it, before you resign, they used to sign this one, that similar work we should not do for so many years. And if they end up in suing, they have all rights to come back and raise a legal case on us. So this is about trade secret. Then what are the importance of trade secret? So trade secret, very important things, gives you a business, especially at the end, it is all coming down, boiling down to money. So it gives you a very good edge to your business in the market. So if you have a competitive value like Coke, I talked about Coke or KFC, and there are a lot of other brands also who have kept these trade secrets. So it gives you a competitive edge on your trade secrets, which on your business basically in the market. Followed by that, your value preservation will be good. As long as the secret is not known to anybody, it can be indefinitely kept. Okay. If you try to leak out to somebody, that fellow will tell to somebody, and if it leaks out, then all the importance of trade secret will be leaked out. So that's why most of the MNCs try to keep the hierarchy system for an employee to who is doing a testing. He has to do testing. His role doesn't implement him to go and see what they are manufacturing. So that's how they try to keep the value preservation. And at the end, importance confidentially is maintained. It ensures that competitors or any other people who are working for us do not steal it, go do a reverse engineering or try to replicate the business process. We are doing it in India. A lot of them are doing it. Why they are doing it freely? Because nobody has the right to question them because they would have not trademarked it. They would have not registered it. So what people are doing it now? They started doing it. You all know a lot of pharma brands like what are drugs or tablets or capsules or sachet we see. When it comes to pharma or FSSAI, this one, they are all branded and they have a name, they have a labeling. So that somebody cannot copy. So that is one very confidential information which gives you upper hand not for anybody to replicate your business process. So that is very important of part of a trade secret. Then, apart from that, how will you protect it? Okay, it is my trade secret. What should I do now? So, as a scientist, I cannot go and start doing my own because I need to follow certain legal laws which are there in my country where everybody is living with. So, first, whenever you try to give it to your distributors or anybody, first we try to do an NDA. When we used to work in my MNCs, most of the vendors whom we used to select, we used to have a three vendor selection. Before we select vendors, we used to do a vendor sampling. We used to analyze where the vendor is, what kind of vendor he is, how we are qualified, whom he is supplying. So based on that, we used to send a legal agreement. It's an NDA, non-disclosure agreement, because you are supplying me some product which I am making a key ingredient. So we used to sign NDAs with them. And we used to tell them, boss, anything which you are deviating as per this clause of the agreement, we have the right to put your legal case if you're disclosing it to somebody else. Then that is an NDA, which gives you a legal contract to protect your sensitive information. Then you have internal security measuring devices where you can limit the access of sensitive information to anybody employee. Like I told you, if somebody is doing a testing of my product, his work is to just do the testing. He doesn't have to know how we have prepared it. So that's how when MNCs we train, no, we say that when business has to run, it has to run not on people. We say the systems will run the business, not the people. If somebody leaves the organization, he may be a key employee. If there is a system in an company, if the key employee goes also, because you have a system there, it doesn't affect your business. That's why it should be a system driven business. It may be any business. It may be an educational institute. It may be a pharma. It may be automobile. If you have a system with a limited access of sensitive information not available to anybody and everybody. So that is an internal security message. If that you have, no NDA is required, no need of any trademarking also. But at the end, if you have, gives you upper edge on your business. Then employee training is very important in these kind of this one. Educating staff about importance of confidentially plays a very important role because where we used to work in MNCs, you still go to MNCs, they have a training program. Anybody joins new, he or she may be experienced or maybe a fresher. They undergo certain kind of training for the whole month, where we try to teach him the systems of the company or the organization, telling that, yeah, this is your role and this is how you should follow. This is how you educate. When I used to work with Biocon, so when you used to have lunch, no, they used to have a specific timing. Morning 8 to 10 is your breakfast. After 10 o'clock, just because you are working for the company, if you come late, no, breakfast is not available. So that's how it talks about systems. If we plan our work in such a way that, even lunchtime was from 12 to 3. After 3, they will not give you anything. And so that when we eat food, the food will not get spilled because they used to give you one tray. So they used to tell within the tray the food falls, we will clean it. Outside the tray, the food falls, you should clean it. Is there is a kind of educating staff they do at the bigger organizations because they spend a lot of money and training people. That helps us also to learn a lot of systems from different companies. Apart from that, legal actions are very important. Somebody is not listening and trying to do their own things. When gives you the employee agreement, and that's how a lot of freshers come and say, yeah, we're not getting jobs. As soon as we say them that you need to sign a confidential agreement for 2 years, 3 years, people don't want to sign it. So that's how this legal actions comes in place, where if you sign an agreement with the companies, they may sue you for a misappropriation if you steal any data or trademark from your from your employer and try to sell it to somebody. So they'll take legal actions. You will not even know that in your employee some clause would have written in the which will protect your trade secret. So in India, trade secrets primarily protects your common law principles, depending on the Indian Contract Law of 1872. So which slowly, depending on the changes, they would have changed, and various legal professions have come into people depending on changes happened, breach of trust and confidential. So they have secret bills passed in 2024 recently has been proposed, depending on the breaching, the kind of company. So they have all reviewed it and they are all putting all this in the Indian Contract Acts so that tomorrow nobody misuses it. Well, certainly there is no specific statutory government governing the trade secret. Yeah, business can rely on agreement policies and digital security to safeguard the agreement. You cannot say the government, yeah, I'm a private organization, somebody stole me, I can't go complain to the government. The government will do it, but depending on the law, where there is, because there is no something that, yeah, the government will come and pitch in, like how we go to the police station, give a complaint, they come up. So here it doesn't work because we should have all this protected rights in our company, and we all do in front of them. And you say that he has stolen, so that time you will not be having any kind of control on that. So you will end up in losing a lot of confidential trade secrets. Now, the two concepts what we have gone through is what is a trade secret and what will be a trademark. How do you differentiate? So if you see the trademark, and the nature is publicly visible. If it is publicly visible, like logos and the names are example. If you come to trade secret, it is private and confidential. Somebody doesn't want to leak out, you'll not know. That is a trade secret. When it comes to protecting trademarks, legal protection through registration, which I showed you in a couple of slides. Here in trade secrets, protection through secrecy is there. And this will be your secrecy is nothing but you are trying not to leach out any information to anybody. So that is your protection through secrecy. And here trademarks is 10 years, followed by again you can renew it. Trade secrets, it's indefinite as long as kept secret, like Coca-Cola, long back 18 something they have been selling. Till now we don't know. So it can be kept secret because nobody knows about it. And value, yes, trademark increases a value over time with your brand recognition. Here in trade secret can lose value if disclosed. If you disclose it, your value is gone. If you don't disclose, your value relays till it is indefinite. So that is the difference. And followed by that, how do you, apart from trademark and trade secrets, once the trademark is done, the next step is you need to register it. You would have seen a lot of brand writing TM next to it. They would have trademark. Once over a period of time, you would have seen some brands writing it registered. So now we'll try to give you an example. What is the difference between a trademark and registered? Trademarks, it is applicable everywhere. You can this one. Registration is again depends on only the country where you have successfully registered your trademarks may utilize them. So I cannot say that I've done a trademark in India and I claim that here in Middle East my trademark. No, it cannot be done unless and until you have gone for an international trademark followed by registration. Again, one more thing is it doesn't offer any legal protection. In trademark, you will not have any legal protection or rights. But when you register it, it will give you total security and protection because you've already registered it. It's as it is mine, you can say. Then this one is utilizing trademark symbols prior to trademark registration is not prohibited. So you can utilize the trademark symbols prior to trademark registration with that. Whereas if we come to a registered one, the use of R symbol prior to trademark is prohibited. You cannot say, boss, I have put it for registration. Unless you get the confirmation, yes, it has been approved, you are supposed to use it. And they'll specify you where to use, where not to use. So before doing that, you cannot say that my product is registered. So it is prohibited. So that has an upper hand when you do a registration. And trademark, you must apply for it registration to protect your brand. You should go ahead and depending on the class with of the products where you're falling, you should need to go and apply the trademark registration to protect your brand. You won't need any need to submit any new application for any additional registration to protect your brand when you register it. And Followed by that, one more, it doesn't provide unique advantages. Trademark doesn't provide unique advantages. And whereas if you register that particular trademark, this one with a registered this one, it increases your credibility of the company and provides you various other advantages also, so that nobody can misuse it anywhere where under your trademark or registered in which other country. So this is the difference between when you do a trademark of your product and register a product. Registration has a more value depending on kind of business you're doing and the market you're tapped down depending on the country. These are the real world examples of trademark. We all know about Nike shoes. I think some of them already know. This shoes was designed by one graphic designer, Carolyn Davidson. She was a designer, who used to work for $3 per hour, and she gave this Nike shoes the most recognized logo worldwide. And today, she did it in May 30th, 1971. The company adopted that shoes. The cost of that only that Nike shoes is it's around $26 billion alone. And the company shoes, because he designed it in such a way in the business, they gave a lot of shares to this designer Caroline because he designed it, and the logo has gone to billions. And in India, we know on the streets, somebody would have copied these shoes. They would have put it ulta, they would have put it in different directions and saying that this is a Nike, this one, they try to copy it. But they would have not written anything. That's why, the smaller players who are selling in the local market on the footpaths and other things, people try to, they cannot sue them because they'll not have any legal right to, so they're just keeping out. But how this is very important. See, the value of that shoes has become $26 billion is something very important because these guys trademarked it in long back. And along with that, about the example of a trade secret, Coca-Cola. We all very know that it has been guarded by a very strong trade secret that kept it over for centuries. People are drinking it. Still, we don't know, and nobody could copy what the Coca-Cola tastes with other beverage drinks which are available in the market. So the Nike shoes is very important logo which has gone. There are similar brands for us to understand very quickly. This is what I shared you an examples of all this. And this for one of my brother's company, I did this actually because my brother is into pharmaceutical company. He gave me a lot of brand names. You can see in this is the email which I'm sharing you, which we submitted to our trademark and IP lawyer. So the following, we gave this left side, you see 1, 2, 3, 4, 5, 6, or 8 what and all numbers. We gave those brand names to the lawyer. So when we say Calotrate is a brand for calcium with a calcium orotate brand. Like we all eat calcium tablets like calcium carbonate and other things. Calcium carbonate doesn't get absorbed in the body. So Corotate absorbs in the body along with vitamin D3. So one of that brand. So he told that lawyer after doing his thorough search as per the law in India, he told lawyer Calotrate it is difficult chances for getting it for registration. He's told that openly. Then when we gave a North pill, he told boss there is one something known as Nerfil. Difficult chance of getting it registered. You can't do it. Change it. He told. Then we had this Pepfizz. So we had made Pepfaz. He told no, you cannot because already Pepsi's the Sun Pharma company is there. So they may difficult chance of getting it. They may put an infringement case on you. You can't do it. Like that, Nutravance is a nutritional supplement of multi mineral and vitamins. So that also he told no, Nutrivens is available. You see, there is a difference of small things on the brand names, but just because it may be some other product, but you will not be able to get a registration. Then we had for the like Gelisil, no? This is we had one Alcocit O. So this is for the gastritis, which they give syrup. So when he told that, he told yes, good chance of getting it registered. So we went ahead and registered this for my brother's company. Then one more was try for XT. So he told no, you can't get it. There is one company already they're saying try for the SLA. So these are some of the cases when you think of some brand name of your company. I've given example of pharma or any other business you do, you try to register it. So this you can check it on the website which I showed you in the earlier this one. You yourself can go to the MCA website. You can put that name. If it is existing, it will show up. If it is not existing, you could say a good chance of getting it. So you yourself can check. But after checking it, you need to submit these to some lawyers who do more thorough check so that completely tomorrow if you really launch the product somebody should not come back. So this has been checked by legal IP lawyers. Then only they'll give you the brand name. So they'll give you an example. Yes, this is difficult to get. You can't. Then we have to work around with the new brand names and go for registration. Then we'll come up to what are the challenges and the risks. The trademark risk of infringement and dilution is more. Challenges in international production, very difficult. And trade secrets, risk of unauthorized disclosures, like we talked about in a couple of slides back. Difficulty in having production of whatever trade secret you have. If it is exposed, your chances and challenges, and these are the risks. If it is exposed, trade secret, you're out. In conclusion on trademarks in this one, trademarks help you protect facing elements like your logos or brand names and other things. Trade secrets protect your valuable, confidential business information. It is both forms of IP which are vital for business seeking to maintain competitive advantages. The final thought is understanding and protecting both the trademarks and trade secrets is very essential for a long-term business success. If you don't protect it, you end up in doing, now you are running your business. That time, yeah, I'm running it, I'm getting my money. Over a period of time, somebody may copy you and go and start doing it. So that time you will realize, yeah, I should have registered it. Now somebody has copied it. So, that's how for long business, people who are doing business long, but they are business people who are smart, who does this so that somebody should not copy it. Then coming to copyright, we all know about copyrights. A lot of them know this one. It is not that you should copy it, right? It may say that copyrightly here. So it's not like that. It is very important. We all know the movie is getting released. It will be already somebody would have done something and copyright. So that's why people started doing a lot of copyright also, which is a part of IP. Now, what do you understand by copyright? It's not like go and copy somebody's in a right way. No, it doesn't say that. It talks about a form of production, somebody's production, who was some creator's production. It may be an original work of somebody's authorship. Somebody would have created it. It belongs to him. That copyright belongs to him. So it is very important to have a copyright depending on the kind of work we do. So this copyrights hold goods, this scope like literature work, music, films, arts, your software, and creative experiments. So we all know, we are from institutes. Plagiarism check also we try to people we do because somebody try to copies and start doing the reports. So that also is a kind of copyright which is very important. Now, what is the purpose of it? It provides creators to own their works exclusive to them who would have created this, so that somebody should not copy what and all you try to do or try to see. We end up in telling ideas to somebody. Someone will be listening, and they, before you go and act, they would have gone and done the copyright if he or she is very sharp. That's why they say don't disclose out anything what you do before coming to certain conclusions. Do not discuss with anybody and everybody. Try to keep it confidential. Do everything by yourself. See how it is. Go talk to lawyers. Have NDAs signed before you discuss with anybody. That is what is the key to this one. So in copyright, what are the key elements? One is originality, next is fixation and creativity. The originality talks about work which has been originally created. It should not be copied from others. Like, in our music industry, Bollywood, we know Anu Malik. Everybody says, he does copies a lot of Hollywood and this one song and tries to change it. So that is a copy. Now he's not doing it because it is till now nobody knew it. It is an infringement. Now infringement has happened. Same way, how do you fix the work? Must be fixed in a tangible medium. It should have a written somewhere and recorded, or it should be recorded in the form of voice or this one, so that nobody alters it. And creativity work must contain minimal degree of creativity. So there are certain rights. Somebody trying to copy a little bit, mine 90%, somebody's 10%. No, there is creativity, minimal degree in a copyright. So, right granted by copyrights, reproduction rights, the right to copy, duplicate, or reproduce. Distribution right, we all know film industry works on a lot of copyrights, production, and other things. The right to distribute copies to public. If I am the film producer of this one, I directly contract the distributor. Then only I give it to somebody this one. I cannot give to directly a theater person who is owning a theater. So there is a channel which has to be go through. So if my distributor is there, I try to sign agreements, NDAs, clause, and copyright laws so that he doesn't infringe. So public performance also is right. The right to perform the work in public is also a kind of rights granted in the copyright. Derivative rights, the right to adapt or create derivative works based on their originals. That also is allowed. Moral rights in some jurisdictions, creators are granted rights to protect their honors and reputation. So that also has been allowed and granted as a right to copyright. Duration of copyright, it can last up to 70 years plus, depending on the kind of work. For work for hire, yes, for employees, copyright lasts for 95 years from publication or 120 years from creation, whichever is shorter. Somebody would have done some copyrights or this one through employees and other things. So this is the age which is the public domain work. They say once copyright expires, work enters the public domain. Like we talked about patent. Patent only has 20 years because they cannot say lifeline patent, it is my own. Because something else is coming up. Yesterday we had a question and we told, somebody's life is getting saved by a old molecule which has been patented and patent is expired. If somebody else is having a better this one, yes, you can go ahead and patent. So that's why they give that time for expiry also. Then what is copyright infringement? Copyright infringement occurs when someone uses copyright work without permission from other holders, without asking them. Examples: reproducing music or movies from without consent. I'll show you a live example which happened 3 days back with one of the Tamil film industry. I'll share this slide also. Downloading and distributing pirated software. This is very common. We all know about it. Before it hits the theater, somebody would have downloaded it. Somebody would have recorded in the theater, put it on the various YouTubes and other channels. Users mix images or texts from the internet without authorization. You see nowadays you want to download some image. Now I have downloaded a copyright image. They would have put somebody would have put under behind that somebody has authorized. You will see that logo also. So they say that images also are without authorization. You cannot use it. Common types of infringement: unauthorized copying somebody's work without permission. Plagiarism, we all are aware, using someone's work as your own. File sharings are not allowed, depending on the networks. Public performance, showing movies or playing publicly without license are not allowed. Then civil penalties. If you do all this, you end up in going for of infringement penalties. Civil penalties may held up hefty fines, lawsuits for damages and injection. If it is depending on the infringement or copyright infringement, it can end up in criminal penalties. Infringement can really lead to criminal charges, fines, and even imprisonment. Statutory damages: copyright holders may be statutory damaged even without proof or harmful act. Somebody copied, and there'll be a lot of guys who get angry and go and damage the properties. We are all seeing nowadays a lot of this one people without taking consent, they come and damage the properties. Then they ask sorry and other things. So that is very important. So how do you protect the copyright? Go ahead and register it. And register with the government agencies. Example: US copyrights. You want to do it, you can do that. Gives you a strong legal protection. Licensing: go license out. You want to license out, you can license out. There is a permission to license out under certain agreements. Watermarking, digital management techniques to protect your digital content. A lot of watermarks are behind your letterhead, your college letterhead. You have a watermark of your college logo. Those are all the kind of copyright protections which you can do by using this. Then what all can be copyright protection? It can be literature work, musics, including any accompanying words, your dramatic works, your pantomimes and choreographic works. It may be your architectural works, which handle your design, your sound recording, motion, pictures, other visual works, your pictorial graphics and sculptures. This one can all be copyright. If something new which nobody has done, you can go ahead and start registering it. I'll show you real life examples of copyright infringement. We all know my previous speakers talked about Napster's case and Google Books and all, and where people started doing copyright infringement, and there were a lot of legal infringement on them, and they went ahead for all this. So these are the big companies who were ended up in having these kind of issues with different people. Software is the mostly done. This one's even pirated software. Major companies like Microsoft and Adobe cracking down illegal software use. We had one automatic fermenter which used to do fermentation of probiotics, and we had given out to this one company who used to sell us a fermenter. And there was a Siemens software which was around 4 lakh rupees, which we gave it to him. What this man did is, he went in and did a um, illegal cooked up software, which shows similarly to Siemens software. And when he gave it to us, and it was having a lot of issues. Then what we did is we called to contact Siemens and we called a concerned person. He told, sir, this is not the original copy they have given you. They have given you a cooked up version. Then we had to go and fight a case against that person for giving us a, in spite of taking the software full money, he gave us a cracked version. So these are all pirated softwares. That was very difficult for us to run the software, because without touching that, I can't run my fermenter, because it needs to have a lot of issues. So that is one very good example on softwares where, software companies who create all these process recipes for manufacturing, if they somebody cooks up that data and gives you a crack version, it will not be useful. About computers, no, they'll give you only 1 year warranty. Original they will not download out. We in the computer also. So it is very important to have a copyright. This one. Then this is the recent case which I was talking about. This April 15th case. I saw it in my this one, the news which I overlook all activities. So this is the recent case of copyright infringement. We all know Mr. Ilayaraja is a composer, and recently there was a Vijay movie where, without asking his consent, these people have used these old songs of 1982 and 86 and 1996 movie song in his latest movie, and they have not taken any legal notice, permission from the veteran composer. So when he saw that there are all trailers coming up, he went ahead and sent a notice to this one with a compensation of 5 crores compensation. So this was the latest copyright infringement which it has happened. So the notice was sent to the Naveen Yarnani and the my three movie makers, who are the movie makers for these three in the movie, and without obtaining any consent from the authorization, they end up in having a copyright infringement, which later has gone to up to compensation of 5 crores. This is one of the recent case, just 3 4 days back. And some old case, I'll show you one more Amul case. We all know about Amul. Amul is not famous in here in down south, but when you go to North and Gujarat and Maharashtra, you get a lot of stuff of Amul products there. What is four names which I've highlighted? No? The four names, Mohit, Akash, Chandru, they all went and they did some work in North America. They took this uh, favor of Amul. They put a case actually, Amul India, on the Federal Court of Canada, favoring this one. They went ahead and started selling this same thing in Canada. So the Kaira district of Gujarat cooperative, who handles this Amul brand, they filed a case on Amul Canada. After discovering that in 2020, they copied the Amul trademark logo of Amul, and the taste of India, which Amul writes. They copied that and they were selling it in without their consent in Canada. So they figured out this, and the trademark logo was we are all, everybody is on phone nowadays. So somebody told that there is a fake LinkedIn page on Amul Canada. So they went ahead and saw that these people have already, without their consent, they were selling this in Amul Canada. So those people were put a case, an infringement case, and were selling it. So they were caught hold and they are under legal issues now. So this is also one of the infringement copyright case of Amul, and that was the this that. How do you protect this? So there's a Bernie conversation which talks about international agreement, ensuring that we all can protect it. All members over 170 countries, you can do a protection depending on the country where you do the. So even global copywriting, like how we have global patent by international PCT, you can do a global copy protection also, which is supported again by WIPO. So WIPO is a very good this one, which takes care of a lot of IP issues with trademark, trade secrets, and your copyright protections. So the WIPO US UN agency promotes the production of this intellectual property globally. If somebody wants to globally, you can go with this WIPO people, and they have a lot of this one which can be help you protect your this one. So coming to my conclusion on this, the copyright protects your creator's right to ensure that whatever innovation he has done remains with him without somebody misusing it. And somebody misuses it, there are a lot of infringement cases which are lead them to a lot of financial consequences, even leading them to legal issues. So always, we all try to copy a lot of stuff. I mean, Google is there to search and see what kind of things we can learn from it, and example exists. But you should not go ahead and try to copying somebody's data or somebody's names or this one. So that is always, you should take a permission to license it out, or copyright, have a copyright, or go and ask them, yeah, I'm interested in this. If you have money, why don't you give me out so I can pay you this? So these are the legal ways to tackle. Go sign NDAs with them, talk to them, discuss with them, if you have a good business proposal, word after them. If they're not interested, we cannot force anybody. And just because they cannot do anything, we don't have the right to go ahead and take out his details without his permission and start selling in the market. Then we'll end up in having a lot of legal issues to us. So that's what I have on these slides, which I wanted to tell you. Hope I have delivered most of the information in a simpler way where people can understand. That's it from my side, ma'am.
Okay.
Anybody has any questions or any doubts, please feel free.
If anybody is having any questions, you can please put it in the chat box. Also, feedback link is shared over here. You can fill the form. Any questions from the participants?
Anybody has any doubts? I mean, I know this is some IP is something difficult for people like us and this one, so it's not easy for us to quickly understand it. Over a period of time, when you start working on all these things, only you'll be able to understand. So that's why from 3 4 days, I thought, yeah, I should have it a simpler presentation so that everybody understands it's what. That's why I made it a little simpler on so that everybody can have a understanding of it.
So, no questions from the participants? Okay, thank you, sir. Thank you so much. I acknowledge you for sharing your expertise on IPR, your insights on trademark, trade secrets, copyrights protection, by giving some good examples, which was valuable, informative, and engaging. So we are grateful for the terms and the efforts what you have put into sharing your knowledge, sir. And I also thank you for accepting our invitation and being an integral part of our event, sir. Thank you so much.
Thank you, ma'am. I thank the MMK and SDM and the organizing committee for giving me an opportunity in having this. And this is something new, which which requires some faculty development is very important actually. So I really thank the organizers and the MMDK and SDM for giving us a second. Thank you.
Yeah, and also a sincere thanks to our principal, Professor Bharti N, and our IQAC coordinator, Srimati Sukrita KS, for giving me the opportunity to host this session. I thank all the participants for your active participation and also the organizing committee members. Thank you all.
Thank you, ma'am. Thank you so much.
Thank you, sir.
Yeah. Thanks.
Thank you, sir.
Thank you, ma'am. Thank you so much.